latest weather, traffic, and news updates online at 560theanswer.com. Now, from the Signature Bank Studios, this is Chicago's Morning Answer with Dan Proft and Amy Jacobson on AM 560. The Answer.
Top of the morning, Dan and Amy. Federal District Court injunctions. They were almost unheard of before the 1960s. Only 12 were issued against George W., 19 against Barack Obama during each of their two terms, two-term presidents, 19 each, Obama and W. Biden, 28. But Biden was one. It didn't matter, as he famously said in the student loan case. Supreme Court tried to stop me, and they couldn't stop me. And this amid all the hue and cry about Trump allegedly not abiding court orders, which is untrue. Trump, by comparison, so 19 and 19, two terms for W and Obama, 28 for Biden. Trump faced 86 during his first term, almost all issued by Democrat-nominated and confirmed judges. 2 months into the second term, he's already at 15. And there are several that I would argue are so obviously within his authority, like those having to do with his plenary power when it comes to border security, that it really is becoming a bit of a problem. Not a problem that is without remedy from within the court system. And this is a point that is made in an op-ed in the Wall Street Journal by Elizabeth Price Foley, who's a law professor at Florida International. She cites, it's an interesting argument, I haven't heard this one, but we've heard, as we discussed yesterday, we've got a pronouncement from Clarence Thomas in the travel ban case back in 2018 speaking to this issue. Alito has spoken to this issue. Maybe it's time for the court to act on this issue. The Rules Enabling Act of 1934. I know it's one of those old laws that are no longer applicable because they're old. This is the argument that was made against the Alien Enemies Act, you remember, just over the last couple of weeks by Democrats. Rules Enabling Act. Nationwide injunctions are issued under Rule 65 of the Federal Rules of Civil Procedure that was promulgated under this act, this 1934 law. Rule 65 authorizes district courts to issue preliminary injunctions, but is silent as to whether they have nationwide effect or apply only to the parties before the court. This ambiguity can be cleared up by the Supreme Court because the statute empowers the Supreme Court to, quote, prescribe general rules of practice and procedure, unquote, such as the Federal Rules of Civil Procedure. Okay. Does Professor Foley have something there? Well, let's ask Professor McCarthy. Andy McCarthy joins us now. Of course, he is former Chief Assistant U.S. Attorney for the Southern District of New York. That would be Manhattan. And contributing editor at National Review, also the author of the bestseller Ball of Collusion, The Plot to Rig an Election and Destroy a Presidency. Andy, thanks for joining us again. Appreciate it.
Oh, it's my pleasure.
What do you think about that argument about that Rules Enabling Act of 1934 and this as the path for the Supreme Court to provide some clarity on the effect of preliminary injunctions issued by district court judges?
Well, that act's actually been invoked a number of times over the years when they tweak the rules of civil procedure. I think it also applies to the rules of criminal procedure as well. So it's not. I think it's a good idea because my view of this, for what it's worth, is that we ought to be pressing on all fronts on this issue. I mean, the hope would be that the Trump administration gets a case in front of the Supreme Court where I think at least three of the justices and potentially more of them, because I think a lot of the justices don't like the emergency docket. I know Justice Barrett doesn't, Chief Justice Roberts doesn't, and Elena Kagan, Justice Kagan, one of the progressive judges, is on record saying that she thought it was loopy that a single district judge in a single district could make policy for the whole country. Of course, she said that while Biden was president, but nevertheless, she is on record having said that. So I think, there may be a majority sentiment on the court for the idea that this is not good for the country. And if they would just rule that way in a case, if the issue presented itself, that would be the quickest way of dealing with it. But, there's other proposals. I think there's no perfect way to deal with this because it's a messy system. There's a lot of litigation all over the country, and appeal is a slow process. But I like the idea, I think, of a rule that basically says the judge can only issue a ruling that affects the parties in the case. Mm-hmm. There are other proposals. I think Chip Roy has one. Mike Lee has a similar one where you get like rapid fire appeal. I think Mike Lee's idea is to set up a court for that purpose, like a 3-judge panel that these injunctions would quickly go to. Whereas I think the other proposals are that you don't want to have that just in Washington and no place else. So maybe you let all the circuits do that, but have a process that basically if a judge issues a nationwide injunction, it immediately goes to a 3-judge panel in the circuit for appellate purposes. I think that would be better than what we've got. To my mind, it would be best to just take the authority away from these judges to issue these nationwide injunctions. But to my mind, let a million flowers bloom.
Well, and so what is? I mean, barring some legislative action, is the Alien Enemies Act case before an appellate court now? Is that the most likely case for the Supreme Court to pick up to perhaps opine on this matter? And if so, what sort of time horizon are we looking at?
Yeah, I don't know if the Alien Enemies Act case is going to do it because I think there's two different issues going on with that case, and there's been a real shift in the emphasis of the case. So I think when it was initially brought in, the issue was, does the president have the authority to invoke the statute when it's not wartime and it's, you could make an argument that there's not an invasion or a predatory incursion as those terms were understood in 1798. That was the argument at the beginning. I think since Judge Boasberg issued his ruling earlier this week, and then the Court of Appeals, the D.C. Circuit, heard the case the same day. The issue now in front of the court is really due process. What they're basically saying is, let's assume for argument's sake that Trump has the authority under the statute to invoke the Alien Enemies Act.
He can't do it in Moss. The question becomes,
well, he can, and maybe he can, but the question is, do they get a right to, whether it's by a class action or individualized, do they get a due process right to challenge their designation as alien enemies under the proclamation? That is to say, assume the proclamation is constitutional and legal and fine. Don't these guys still get a right to contend that they're not what Trump describes in the proclamation? And the Justice Department has now conceded that they do get a right to some due process, which I don't think is going to be much help to the people who are already in the Salvadoran prison, right. But for the remaining Venezuelans. So that's I don't think that that case is the vehicle, but there's plenty of cases coming.
Well, which one? Which
one's the?
Yeah, I mean the federal workers case.
I thought the USAID case had a shot, and I think that Judge Amir Ali kind of laid the groundwork for future proceedings. That thing sort of went by the boards, but he also said that he was making he was prepared to make a finding that the administration can't cancel out foreign aid spending that Congress has appropriated. So that's a looming issue that potentially could go up. And I do think you're right that these Doge cases and particularly the one where the judge in California told them to rehire 16,000 people or something. I think that could go up in a hurry.
What about transgenders in the military?
Yeah, that's another
that
case
case?
that could absolutely go up. Well, look, I think a lot of these cases, I'm at the moment when we started our conversation, I was writing about this undergraduate student at Columbia, who's very similar to the Khalil case, except she beat Khalil to the courthouse. I mean, basically, the feds went out and got Khalil, and this woman decided to get her lawyers to go to the Manhattan federal court before the feds could arrest her, and she got a judge to basically tell the feds not to arrest her at this point. I think the reason I mention this case in the context of the trans case is a lot of these cases, I think, are about the question of who gets to decide. There's one issue about whether, something is reasonable and whether it's in the government's interest to adopt the policy that the Trump administration wants to adopt. And then the second question is, well, who gets to decide what's reasonable? So, in other words, should a federal judge supplant his or her assessment of what military necessity is for the Secretary of Defense's assessment? Or in these cases that involve these Columbia students, if the Secretary of State makes a finding that the continued presence of those students in the United States has bad consequences for American national security, does a federal judge have a right to come in and say, well, I don't think that's reasonable? Or is it, as I believe, a decision that Congress has committed to the executive branch, particularly in the foreign affairs realm, where the executive branch has a lot more authority? I think you could say this about the trans issue too, because the president is the commander in chief. In certain aspects of our governance, the executive has more authority than in other aspects. So, for example, I always thought Trump was on stronger footing going after USAID than he would be, say, trying to close the Department of Education. Because when you're talking about foreign affairs and national security, since the founding of our constitutional government, those powers have been areas where the executive is supreme for obvious reasons. Whereas when you're talking about domestic regulation, that's really Congress's bailiwick, and it's a lot harder for the president to come in and say, I'm not going to spend the money that Congress has appropriated. So, there's a lot of moving parts here, but I think what the Trump administration is going to be looking for is a case where they can go up to the Supreme Court where the issue is something like control of the military or control over foreign affairs or control over foreign spending, where the president has more constitutional authority.
Right. I mean, it's while these federal district court judges are playing whack-a-mole with Trump initiatives, do you have any doubt that ultimately the Supreme Court is going to take up one of these cases that is challenged for the express purpose of dealing with this issue, this fundamentally problematic issue of the power of federal district court judges and the impact of their injunctions?
I do think so, but I don't think it's because I think you and I would probably say this has to be dealt with because otherwise the court is preventing the government from functioning. I think that'll be part of it, but I also think the thing here is it's in the Supreme Court's interest to take a case like this, and the Supreme Court is very good at pursuing its own interests, just like the executive branch can be. Here, I don't think, to go back to the beginning, I don't think the justices like dealing with this emergency docket. And every time a judge issues a preliminary injunction that ends up making national policy, what happens is those cases end up in the Supreme Court lap at a very preliminary stage of the litigation. Mm-hmm. And they have to be dealt with because the district judge has tied the government's hands. And the one who's been, I think, loudest complaining about this is Justice Barrett. And her point is that most cases that come to the Supreme Court, they take a couple of years at least to get there. And by the time they get before the justices, everything is crystallized in terms of what the issues are. They're fully developed factual records. It's not a situation where after the court makes an important ruling, some new facts are going to develop that make it look bad because, they weren't considered when the ruling was made. They don't like the emergency docket. So I think it's in their interest to stop the dynamic that gets these cases up there at that preliminary stage.
Well, exactly. Yeah. I mean, Justice Barrett then should take judicial notice of how this has been used, is now used in the modern era as a political weapon by both sides. And so deal with this underlying issue that is nebulous. I mean, so it's like she's complaining about something that she sees that she should have sort of full view on, number one.
Yeah, absolutely. I was not trying to suggest that there was anything.
No, I hear you.
I think she's absolutely. Can I tell you one other thing? Because I looked this up since I thought you'd be interested in it before we got on.
Yeah.
In their 12 years in office, Presidents Obama and Biden appointed 569 judges to the federal court.
Wow.
There were about 833 slots. So I think two things are going on here. Mm-hmm. One is you're dealing with a swath of progressive justices because the Democrats were in office for 12 out of 16 years. And then I think one thing that's very different today than when I first started to practice law in the Stone Age is that culturally, judges don't care as much anymore about getting it right and not being reversed. When I started out as a lawyer, it would always get a trial judge's attention that he or she would or could be reversed by the higher court. They took pride in not getting reversed, even no matter what their political baggage might have been. Nowadays, I think culturally, progressive judges don't care if they're going to get reversed by the higher courts. They prefer to show that they're on the team, and maybe someday that means a progressive administration will, promote them to the circuit court or promote them to the Supreme Court. And these progressive administrations appoint these activist judges precisely because they don't really care what the law says, that they'll crank out progressive results.
They also don't care about obvious ethical conflicts of interest like we see with Boasberg and we've seen with others. But I want to get your reaction to something else, too, because this comes from Speaker Johnson, who, number one, is an officer of the court, and number two, is not prone to hyperbole like many politicians, even in the speaker's chair. He said, we do have authority over the federal courts, as you know. We can eliminate an entire district court. We have the power of funding over the courts and all these other things. But desperate times call for desperate measures, and Congress is going to act. I mean, do you take that as just another shot across the bow of John Roberts to say you better deal with this?
Yeah, I do. I mean, because as a political matter, it's a dead letter, right? I mean, I don't know that he has I don't think he has a majority in his caucus for that position, and it would be a non-starter in the Senate where you'd need 60.
And one other thing. Speaking of Johnson and Republicans in Congress, is there anything on these matters that they should be doing rather than just piling on, in back of Trump on the federal district court judges that are enjoining his policies? Anything Congress could be doing on any of these issues that they haven't taken up?
Yeah, I thought, and I wrote about this a couple of days ago, I thought that rather than talk about impeaching judges, which is another non-starter, I mean, it's just not ever going anyplace, I think it would be, in connection with the Venezuelan case in particular, I think Congress ought to enact, I think Republicans ought to propose in Congress laws that give Trump the unquestioned authority that he's claiming by construing the Alien Enemies Act. And you could also curtail, because Congress is in charge of the court's jurisdiction. So there's a lot of statutes that basically say, if the secretary or the president or someone makes a decision, the courts can't review that. They could be enacting some law, and even if, because of the tightness of the margin in the House and the fact that you need 60 in the Senate, maybe they can't get it through. But if it puts the Democrats in the position of defending Tren de Aragua. To my mind, if that's what the if the Democrats want to defend the Venezuelan regime and Tren de Aragua, the Republicans will let them do it.
Yeah, absolutely. Andy McCarthy, former Chief Assistant U.S. Attorney, Southern District of Manhattan, contributing editor at National Review, author of the bestseller Ball of Collusion, The Plot to Rig an Election and Destroy a Presidency. Andy, thank you as always. Appreciate it.
Thanks, guys. Have a great day.
You too, and he joined us on our turnkey.pro answer line.
You're listening to Chicago's Morning Answer with Dan Proft and Amy Jacobson on AM 560. The Answer.
Patrick was way behind on his IRS taxes.
I was in way over my head. The total amount ended up being somewhere just over $30,000. $30,000.
Then the IRS came to collect.
Started getting letter after letter. A lien had been filed against me. They were going to basically hang me completely out to dry.
He had to do something.
That's when I reached out to Optima Tax Relief.
Patrick's life quickly got a lot easier.
It was very easy, pretty much hands off. They picked up the ball and ran with it.
And how'd it go?
I couldn't believe it. I had to ask 2 or 3 times. I saved an incredible amount of money.
How does Patrick feel about Optima?
Couldn't be happier. They definitely helped me. Optima Tax Relief, the best place to call. They're the best in the business.
Do what Patrick did and call Optima Tax Relief for a free consultation. Call 800-965-1433. 800-965-1433.